Yes. Welcome to the Law Professor. Um, Today's topic will be considering the doctrine of novus actus intervenis. Novus actus intervenis. What does it mean? In the thought of negligence, of course, in the thought of negligence. And this presentation will be in two parts for clearer understanding. So I would enjoy that you watch the second part of this video. I also would enjoy us to like the video for better coverage and subscribe so you get notified as we upload new videos. So today's presentation, novus actus intervenis. What are we talking about? What are we talking about in the thought of negligence? We are still on this question of the finding liability, so to say, finding liability, and we are trying to say that in some context, even when the but-for test has been fulfilled, has been met, that the court might still say that a defendant that is before the court is not the true cause of the damage to the plaintiff or is not the sole cause, and that something or someone else is responsible for the damage. And what are the learning outcomes for this presentation? At the end of it, by the time you listen to the two videos that we were talking about, you'll be able to understand and apply the meaning of novus actus intervenis in cases relating to the sort of negligence. You would be able to appreciate the context of application in this regard, where somebody is raising the question that what actually caused the damage is an act of God, or it's an act of the third party, or it's even the act of the claimant. How do we, go through the various facts and determine which act actually caused the damage to the plaintiff? Then you'll be able to understand and apply the relevant principles as developed in tort cases. Issues like, is foreseeability necessary? What is the place of unreasonable conduct as a novus actus intervenis? And eventually, you would have developed competencies to give legal opinions in real-life case situations. Now, conceptual clarifications are needed. There's a distinction between what we call the novus actus intervenis from other scenarios in causation in fact. When we say novus actus intervenis, we are saying new acts intervening, new acts intervening. This new act is completely standing on its own legs, unique. It is not flowing naturally from the sequence of events that the plaintiff has created. It is not flowing naturally from the breach of duty that the plaintiff has been, the defendant has been found wanting in. So you are saying this set of events are actually the true cause of the injury to the plaintiff, and the person that is responsible for those events should be the one liable. And so it is different from causation in fact cases where you have two independent causes who have jointly contributed to the damage, and the plaintiff is able to recover from both of them. We talk about joint liability. It's also different from the acts of a defendant as well as the act of the plaintiff, both combining to cause the damage to the plaintiff when you talk about contributory negligence, which we'll be treating in some of the defenses as we go on. So novus actus intervenis, like I said, means a new intervening act. And this new intervening act is regarded as the sole cause of the injury to the plaintiff. Is the sole cause, this true cause of the injury. And the cases that we'll be looking at will illustrate this principle. When that happens, it is normally said that this new intervening act has broken the chain of causation. It's broken the chain of causation between what the defendant has done initially and what has happened to the plaintiff. Oh, the defendant injured the plaintiff, and the plaintiff has a stiff leg. A stiff leg. Then the plaintiff, after that injury, goes ahead to play football with the leg, and the leg suffers a fracture and is and becomes, completely unusable. And the defendant tries to say, no, it was not my injury that caused the fracture. It was because the plaintiff went to play football. So what the plaintiff did is a novus actus intervenis, and therefore I should not be liable. It's a new cause. It was not reasonable for him to go and play football with that leg. So that's one of the arguments you were looking at in this aspect of the sort of negligence. So the issue is that the new intervening event comes after the breach of duty, but before the harm to the claimant arises. So the court needs to decide what is really the cause of the fractured leg. Is it the fact that the defendant ran his vehicle negligently and injured the plaintiff? Or is it the fact that the plaintiff went to play football, for instance? These are some of the considerations before the court. And so this issue actually creates an overlap when you are trying to discuss questions of, oh, is there even a duty of care in the first place? And then the issues of defense, some of the defenses like act of God, act of third party, and the question of contributory negligence and voluntary non-fit injuria. So sometimes the court would say, no, the intervening act is not a novus actus intervenis because it just shows that the plaintiff was unreasonable, but the chain of causation is still proceeding. And so they may decide that it's a case of contributing negligence and apportion the liability between the plaintiff and the defendant, or between the defendant and another third party who created the subsequent event. The issues regarding novus actus intervenis, just like we have talked about in legal causation cases, is premised on case facts, the facts of each case. If Lord Neuberger, for instance, said in Wright and Cambridge Medical Group that when you have successive thought fissures, for example, the example I've given, you went to go and play football, it may not even be a thought that the subsequent event represents, but it could also be a thought. When you have successive thought fissures, and there's a contention that the causative potency of the first thought fissure, for instance, in the example that I've given, the defendant that drove his vehicle negligently and injured the plaintiff, that the potency of his thought has been eliminated by the subsequent event. What was the subsequent event in the example? The act of going to play football. That you need to look at the facts of each case to determine if actually, for instance, this act of the plaintiff in going to play football has broken the chain of causation. So it is fact specific. Then we have the general principles of law, which we are going to be looking at in this presentation, but it is actually the facts of each case which tell us whether there is foreseeability, whether it's reasonableness, whether it is deliberate, intentional, or what have you. So, and Lord Wright in the oral question also said that it may be said that in dealing with the thought of negligence, it is possible to state general positions. You can say principles. You can say, oh, once the act is unreasonable, the plaintiff is contributory negligent, or it is novus actus intervenis, for instance. But when you come to try and apply those principles to determine whether there has been actionable negligence in any particular case, you must deal with the facts of the case. You deal with the case on its own facts. So in terms of context, when you are looking at these intervening acts, usually we talk about intervening acts by third parties or intervening acts of the plaintiff himself. Defendant says, look, it's for you as a plaintiff, you should have gone for medical treatment. If you didn't go for medical treatment for the injuries that have caused you, then I should not be responsible, or you should not have gone to play football, or you should have done a particular thing to mitigate your loss. Or act of third parties, where a third party does something in the scheme, in the chain, and says, oh, look, somebody else. Yes, I know that I left the door of your house open, but I was not the one that caused the damage because thieves broke in. These thieves are third parties. They've done an intentional act. I should not be responsible for that intentional act. These are considerations. The courts have developed some principles to say, oh, these are the considerations that will come into play in such arguments. Now, the possibilities are these. When you have multiple successful causes like this, different thoughts or different wrongdoings, or even when it's not a wrongdoing, but it's an intervention, the court might say that there's only one single legal cause and that cause is a novus actus intervenis with regard to the defendant that is before the court. Oh, this defendant has injured plaintiff A that we are talking about with his vehicle. He has a stiff leg from that injury. The court might say it is that wrongful, negligent driving that caused the injury to the plaintiff. But the defendant argues and say it is the court. What is the injury before the court? Oh, the plaintiff is now trying to claim for a fractured leg. And the defendant argues and says the fractured leg is not a result of the vehicle damage that I caused to his leg, to the personal injury that I've caused him. It was because he did something unreasonable. He should not have gone to play football. So the court is left to decide, is it a joint liability? Is it a contributory negligence case that, okay, both of you are liable and should contribute for the cost of the fractured leg? Or is it a case of a single legal cause, which is what the defendant did initially, that caused the injury to the plaintiff? Now, in terms of some basic principles and general principles, in the case of Clay against TUI UK Limited, and the LJ summarize what are the principles that we should govern any discussion in this area. And he said that the extent to which a conduct was reasonably foreseeable would determine in general whether it's a novus actus intervenis. And the more foreseeable it is, the less likely it is to be a novus actus intervenis. The more foreseeable it is, the more like the less likely it is to be. What is it talking about? For example, in what we have been looking at, when you cause personal injury to a person, it is foreseeable that the person may seek medical treatment. So seeking medical treatment is a natural process, is a natural consequence of the breach of duty. It's a natural process and consequence. And therefore, what happens during the medical treatment, or generally, you will not be able to say it's a novus actus intervenis. Then he talked about the degree of unreasonableness of the conduct. And in general, the more unreasonable the conduct, the more likely it is to be a novus actus intervenis. When the conduct is unreasonable, that it cannot even be factored, it cannot be conceived as a natural effect, consequence, reaction to what the breach of duty of a defendant represents, that is likely to be a novus actus intervenis. Don't forget that we are talking about general principles, and we have said earlier that those general principles may be easy to formulate, but in terms of application, we now need to look at the facts of each case to know whether it actually applies. Then he talked about the extent to which it was a voluntary and independent conduct. In general, the more deliberate the act, the more informed it is, and the greater the free choice involved, the more likely it is to be a novus actus intervenis. Once the act is seen as an independent cause, it doesn't flow naturally from the breach of duty. It is not, then it is likely to be a novus actus intervenis, new intervening cause. That's the meaning of novus actus intervenis, a new intervening cause that breaks the chain of causation. So reasonable foreseeability has been mentioned in that summation, and that you should ask yourself that, look at the sequence of events from the vehicular injury caused by the defendant to the fractured leg, for instance. Is it a natural sequence of events? Or is it something that is extraneous, something that cannot really be seen as a process that flows naturally from the defendant's negligence? So where the act is independent, completely extraneous, extrinsic to the event, then you talk about the fact that that act is in novus actus intervenis. And where the act is unreasonable, then in most instances, such unreasonable conduct will break the chain of causation, will constitute a novus actus intervenis. But again, this rule is not absolute, as will be seen in the case applications that will be taken in the next presentation. And in such cases where it is sometimes where the act is unreasonable, the court might hold and say it is a case of contributory negligence, where it is from the position of the plaintiff himself. Oh, you have a stiff leg. Why should you go and play football? It is an unreasonable decision that you have made. Well, this fracture is, you have also contributed to it. Because of course, we know that that stiff leg has made you more prone to it. So contributory negligence may come into play. Some of the cases will depict this. So, and we are also saying that from that, those general principles that willful, intentional, and deliberate wrongdoing will likely break the chain of causation. Again, This is not necessarily so. Some willful conduct will not break the chain of causation, where, for instance, it will negate the duty of care. If, for instance, like in stance B and trauma that we talked in earlier presentation, you have a duty to lock the door of the person that's left you in custody of their property. You left the door open and thieves break in. The thieves that broke in have committed a deliberate and intentional wrongdoing. It does not lie in the mouth of the person who failed to lock the door to say, this is a new intervening act. All I did was leave the door open. It is the very essence of your duty to lock the door that you prevent thieves from coming in. So that will not negate it. So we'll be looking at some of those principles in terms of application. And then reckless or grossly negligent wrongdoing may constitute a novus actus intervenis, a new intervening cause. Don't forget, like I said, that once it is held that a set of events is a new intervening act, then it means that it has broken the chain of causation. And the defendant that you are suing in the present litigation will not be held responsible. Okay. The essence of these principles is therefore that they should guide us in terms of how to determine whether the particular defendant before the court is liable or is not liable. In terms of species of intervening acts, in this presentation, we just briefly look at where you have natural events. Natural events, or sometimes we call it act of God in the law of thought, that where what are set in as an intervening act is a natural event that is an act of nature, act of God. Generally, this would break the chain of causation, and the defendant may not be liable. The illustration is seen in the case of Colors Geek Steamship Company Limited against Royal Norwegian Government Limited, where there was a collision between two ships, and then the plaintiff's ship was damaged and it was repaired temporarily so I proceeded on the voyage to New York to get complete and comprehensive repairs. But during the voyage, it experienced heavy weather, which damaged the ship to caused considerable damage to the ship. The initial damage would have cost them about 10 days in port to repair the ship, but now with this extensive weather damage, it cost almost 30 days. And the House of Lords held that the claimants who caused the initial damage were not responsible again. It was a case of a new intervening cause, an act of God, and that it could not be liable for the 30-day repair that took place. Because by the time the ship actually got to the New York port, it was a damaged ship. So these are some of the considerations in terms of the natural event. However, while a natural event, an act of God, could cause a break in the chain of causation, sometimes if it can be shown that the breach of duty of a defendant has either increased the likelihood of the natural event or made the claimant more susceptible to that natural event happening, the court might hold that the natural event, the act of God, did not break the chain of causation. So in rare cases, defendants have raised this defense and the courts have had to hold that there is no break, that there is a break in the chain of causation where it is established on the facts that this is what actually occurred. So in the next presentation, therefore, we'll be looking at the act of third parties, and we are going to be looking at the act of claimants as possible acts that constitute novus actus intervenis that break the chain of causation.